Hi, I'm Daniel Hunt. I'm a certified legal specialist in estate planning, trust, and probate law. Most of the cases I handle these days involve trust and estate litigation. This type of litigation usually involves trust beneficiaries taking legal action against a trustee. If you're a beneficiary wondering if you should invest time and money to pursue legal action against a bad trustee, you probably want to know if you have a case. In part 1, I explained what circumstances may give you a legitimate claim. In this video, I'm going to share how to sue a trustee and explain the basic steps of this process. First, seek legal representation. Trust and estate litigation is a highly specialized niche. Most estate planning law firms either don't handle litigation matters at all or have very little experience doing so. For optimal results, find an attorney who is experienced in trust and estate litigation specifically. Second, file a petition with the court. California Probate Code Section 17200 is the most common code section used to petition the court for relief in matters such as these. But other code sections may apply more accurately to your case. An experienced trust litigator can help you select the right one and maximize your chances of success. Third, serve the petition to the trustee or the attorney or law firm representing them. Fourth, appear at a court hearing with your attorney to present your case to the judge. Fifth, the judge's ruling dictates what comes next. The judge may grant your petition, deny it, or set an evidentiary hearing to collect more information. Alternatively, both parties may schedule a settlement conference or use a professional mediator to try and work out a solution. With that overview laid out, I want to offer 2 important questions for you to ponder before proceeding with legal action. First, do you have enough evidence to win? The person suing a trustee bears the burden of proof to prove that the trustee has behaved unethically and should be removed. Second, does the trust include a no contest clause? This common trust clause is intended to discourage frivolous attempts to overthrow estate plans. If the trust contains this language, you may find yourself disinherited if you bring a suit. Be sure to have an attorney review the trust, if you have a copy, before bringing a suit, and discuss with them the ramifications of legal action on your inheritance. Finally, let's talk about money. Who pays the legal fees? If you're a beneficiary considering suing a trustee, you will need to find assets to fund the suit on your own. Eventually, you may be able to ask the court for reimbursement of your legal fees, but you will need to pay out of pocket to retain legal counsel and start the litigation process. If you have any questions about trust and estate litigation, feel free to contact our office. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.